Sacha Morisset. Bonjour. Alors, Sacha est avec la firme Stewart, McKelvey, c'était Sterling Scales avant, but no, just okay. Who's going to speak to us about the New Brunswick Municipal Commission and the impact for cities. C'est bien ça? Bienvenue. Yeah, the clicker's right there. Right. Okay, super. Be all set for you.
All right. Well, that's right. Well, good morning, and thank you for having me over to discuss the upcoming new Local Governance Commission. So some of you may have had a chance to peruse the act that's been passed by our government, which is not yet enforced, but when enforced, will be effectively creating this new commission. So currently, there is no single body with an overarching oversight on the various aspects of municipal affairs. But in the context of the latest reform of municipal governments and municipal regimes, one of the ideas was to create this single commission that would essentially take over oversight and investigation of most of the things that are currently being looked at, investigated, or adjudicated upon by various different bodies. So as I mentioned, the act has been passed, but it's not yet in effect. So stay tuned for that. So currently, as I said, there are multiple bodies or offices that exercise oversight over municipal affairs and investigate various matters. The idea here is that we are going to take these powers, for the most part, away from these other bodies and concentrate them into this new commission. And this idea of a new commission or a big commission that has vast powers and obligations and oversight is nothing new. So there's been a push towards similar models in other areas of our legislative regime. And I would argue that it tends to make sense as well in a small province like ours to try to concentrate expertise in one single place and hopefully achieve better outcomes and also more efficiencies. So right now, some of the powers that will soon vest into this commission are exercised by the Assessment and Planning Board, the Commissioner of Municipal Affairs, Regional Service Commission boards, and of course, municipal councils. So currently, the minister, of course, has a lot of powers and oversights with respect to municipal affairs, and how the commission will sort of fit into this model is it will take over many functions, but will also act in a lot of ways as an advisory body to the minister, with the minister retaining ultimate authority over certain matters. So if we start by looking at what the commission is going to look like, so members will be appointed by cabinet, and there will be a commissioner named for a term of less than 10 years, but which may be renewed. And then the commission members who will also be appointed, there should be no less than 4 members, and currently quorum for the commission exercising its meetings and its functions sits at 3. So the commission was created, and when it actually becomes operational, its role will be, generally speaking, to review, assess, rule, and make recommendations on a whole host of matters that are effectively spelled out in the legislation. with respect to the administration governance of local governments. It will also make recommendations to the minister. It will investigate certain matters, and I'll get into the details of what those might be. And it will also have a education and advice mandate on matters falling within the Act. The Commissioner has the power under the current legislation to delegate some of its powers to the Commissioner, and so we'll talk about that in a moment. I believe that the reason for that is that some powers which require to be exercised on a more frequent basis, daily or weekly, should rest with one person, and the Commission as a whole meeting and adjudicating on certain matters will do so a little less frequently. So there'll be a Commissioner that will be invested with powers that, are called to be exercised on a more frequent basis, and the Commission will then exercise the rest of its functions. There does not seem to be, the way the legislation is drafted, to be any restriction on what powers can be delegated from the Commission to the Commissioner. The Act cites 2 powers that can be delegated, but it's not an exhaustive list. And so it will remain to be seen which of the powers provided to the Commission will actually be delegated to the Commissioner. But at the very least, the Commissioner may be delegated the power to direct an auditor to audit the financial affairs of a local government, and also the power to require a whole host of people to provide information necessary for the Commissioner or the Commission to discharge its functions. I didn't put it on the slide, but the powers of asking and requesting information are very vast, and reference is made to the Commissioner and the Commission having all the powers spelled out in the Inquiries Act, which is a piece of legislation that provides for vast powers to compel persons to provide information, to enter upon premises, and compel the disclosure of records. So it's not just a question of asking for information, but also having the tools and the legal powers to compel the information to be produced. So when we look at the Act and we look at what powers reside with who, so the Minister, of course, retains a lot of power. So he has the power to generally assign functions to the Commission within the parameters of the Act and the regulation, which regulation has not yet been drafted. So there's a lot of details to come at a later stage. The Minister can request investigations. So when we talk about investigations in a moment, you'll see that the Commission has the power to initiate investigations on its own accord or when requested by various persons, but the Minister can also direct or request that the Commission undertake an investigation. The Minister will, of course, receive recommendations, reports, and audits, and may act upon them. The Minister has a power to repeal or amend a bylaw that is not a prescribed bylaw. And what I mean by that is the Local Governance Act mandates certain bylaws to be passed. So these are mandatory bylaws. Municipalities can, of course, adopt other bylaws that are not required strictly by the Act. And with respect to those optional bylaws, if you will, the Minister has broad authority to repeal or amend these bylaws. With respect to the other bylaws, those that are mandatory, the Minister has the ability to amend or revoke these bylaws, but there are additional steps. And one of the steps is that the Minister will request a study by the Commission in order to seek advice and recommendations and a report, and then the Minister can exercise the same authority with a few more procedural rules, such as providing minimum notice to the local government that is impacted, and so on and so forth. So the message here is that the minister retains a lot of power to amend and repeal bylaws with more or less procedural steps to be followed prior to that ultimate decision. Moving to the commission, so as I've indicated, the commission, and it may delegate that power to the commissioner, it can compel essentially members of a council, of a board of directors, of a regional service commission, essentially the main actors in municipal governmental affairs, to provide information related to the affairs of the local government or the regional service commission. So that's very broad, so they can inquire about just about anything, and as I've indicated, they have the power to compel the information. It's not just you may ask but live with the answer. They can actually compel compliance with their request. The commission is set to have vast investigative powers, so it can inquire into the affairs of a local government, and that's as broad a term as you can possibly imagine. So that's pretty all-encompassing. It can also investigate the exercise by any officer of a local government of the function of their office. So they can investigate how an elected official or another official is discharging their duties of the office that they hold. They can inspect any records, and they can also pretty much determine the scope of their own investigations. So broad investigative powers. The commission has the power to appoint inspectors. So inspectors, and we'll talk about inspectors and auditors in just a moment. So inspectors, if we want, for the purpose of this discussion, we can call them investigators. So that would be persons investigating the affairs of a local government, which is very broad, a very broad term. So that can mean just about anything. The carve-out that we'll discuss in a moment is the power to request audits, and so then we won't be talking about investigators or inspectors, but rather auditors. It's the same thing, it's just investigators with specialized expertise because they'll be looking at financial affairs as opposed to general affairs of a local government. When the commission orders an investigation or an inspection, it, of course, receives a report from the person who's been mandated to investigate. And the Act provides that the Commission can take any action it considers necessary or advisable to address the matter that was under investigation. So broad powers to investigate or request investigations, and broad powers to do whatever they think is appropriate to address the matter under review. So again, powers are very broad and vast here. And of course, the Commission has a duty to account for its activities to the Minister. And so when it does investigate something and makes a decision as to what is required or advisable to be done, then it has also the power and the responsibility to report to the Minister that certain actions will be taken or have been completed. Appointment of auditors, basically the same thing we've just discussed, but with a narrow focus on the financial affairs of a local government. So when an audit is called, and auditors are going to be appointed or mandated by the Commission to investigate a financial matter, and then the Act, of course, provides that it's not anyone that can be an auditor. They need to have the required professional certifications and qualifications. But again, the same powers exist to demand an audit, receive a report, and again, take any action considered necessary or advisable to address the matter. Speaking of investigations and audits, so the Commission can require these things, and the Commission has the power to recoup the cost of these endeavors with the local government that is the subject of the audit or the investigation. The Act says subject to regulation, so there might be limits, but I can't tell you what those limits are today because we have not seen the regs yet. The commission can also call for the review of cost sharing, which falls under, regional service commissions. So they can basically examine how cost sharing is done, and they can, essentially review what a regional service commission has decided in terms of cost sharing between the member municipalities, and it can send the results to the minister and then make recommendations for the minister to act. So they can't supersede, or they can't quash a decision or amend a decision by a regional service commission. But after their review, they can pretty much tell the minister, you should look at this, and here's what we think you could want to do. Proposals for restructuring a local government. So the commission can receive and then report on a proposal to restructure a local government, and that proposal can come basically from a municipal council, the minister, or a group of 25 or more residents. So there are thresholds as to who can require these things, and if it's a citizen-led initiative, there's a threshold of a minimum number of citizens to lead that initiative. But once that request is made to, restructure a local government, then it's the commission's job to review the proposal and again make recommendations to the minister so that the minister can take action. Code of conducts and conflicts of interest. So this is interesting to me because I've conducted several investigations, and it's a little bit more my expertise with respect to municipal affairs. So the legislation is, I would say, somewhat vague to me in terms of what it provides. Because it says that if a matter that relates to an alleged breach of a code of conduct cannot be resolved under the Local Governance Act or the Regional Service Deliveries Act, depending on, which entity is being called into question, or a member of which entity is being called into question. But basically, if it cannot be resolved, then a request can be made in writing to the commission, who will then undertake an investigation. What's unclear about that to me as a lawyer is, what does it mean it cannot be resolved? So how do you determine that something has not been resolved or could not be resolved under the Local Governance Act? That is a bit murky to me. The Local Governance Act mandates that municipalities will have a code of conduct. And it also mandates that that code of conduct has to have minimum features, one of which is a way to receive complaints and resolve them or adjudicate them. So what does that mean? Does it mean then that someone can bypass essentially the procedural steps under a code of conduct? Or does it mean that they can essentially request the commission to investigate if an investigation has been done pursuant to a code of ethics, but somehow someone is unsatisfied with that, so therefore it is not resolved? So I see a lot of head shaking, and I shake my head as well, because I like clarity, especially when I need to advise people on a professional level. What does it mean? So we don't know that yet. And I would argue, so suppose, for example, there's a complaint that's filed under a code. The municipal government decides to mandate an external investigator to investigate. The investigation is completed, recommendations are made, and council adjudicates. That's the current system. If someone is dissatisfied with the outcome, does that mean it has not been resolved, and therefore we can request an investigation by the commission? And if so, then does the commission review the prior investigation, or does it investigate from fresh? You know, so we just don't know all of these things. Perhaps the regulations will offer some guidance and some clarity. I would hope so, because we might eventually get into a situation where the commission will decide that it does not have the power to do something, or that it does have the power to do something, and there'll be court challenges to try to figure out exactly what the role of the commission is and what its powers are and how those powers are triggered. So I think this is a big stay tuned on that front. What I would add to that as well, just for your own reflection, so recall that if there's an investigation made by the commission, it can essentially pass the cost back onto the municipality. So if the municipality has already mandated someone to investigate something, it's been adjudicated, but it's considered unresolved because someone's not satisfied, and there's a second investigation, that doubles the cost of the investigation to the local government, because they'll pay for the first investigation and get a bill from the commission for the second investigation. So again, I think, you know, the idea that the commission could play a role in these things is not necessarily offensive to me, but I think that we need to strive for clarity and hopefully efficiency as well. So stay tuned again for more clarity, hopefully from the government, from the regulations, from legal advisors that will give you an opinion, or maybe eventually the courts who will have to adjudicate on these administrative law matters. So again, so if the commission actually does conduct an investigation into a code of conduct matter, then, you know, of course, it can also issue sanctions, much the same way that municipal council could impose sanction on someone who's been in breach of their code of conduct after a proper investigation, of course. So supervisors are essentially when, you know, someone comes over and takes control over a local government. So municipal council is pushed aside, and there is a supervisor who basically takes control and power and charge over a local government. So the commission can appoint supervisors to take control when a council has defaulted in meeting its obligations or is unable to carry on the business of a council. So again, what does defaulting on its obligation mean? You know, that's not necessarily super clear. One would hope that the commission would not, you know, order supervision over trivial things. And I think that we can certainly hope that the commissioners will be fair-minded individuals. But, you know, again, so, you know, what will be these thresholds to take the extraordinary measure of putting a local government under supervision? And of course, then for how long? Again, stay tuned, perhaps the regs again, and it's not uncommon for the regulation to provide clarity and more detail over something that is more broadly set out in legislation. And then finally, other potential sanctions. So the commission has the power to, upon finding that anyone has breached any disposition, any section of this act, to impose essentially monetary fines, which will be category F offenses, meaning that they can trigger a fine of anywhere between $240 and $10,002, depending on if it's a single breach, if it's a repetitive breach, or if it's a reoccurring breach. So this is not, again, uncommon for legislation to provide for the possibility of monetary penalties for non-compliance, and that will exist as well in this new legislation. And finally, members of council, you know, must not vote to apply funds contrary to the will of an appointed supervisor, and if they do, they can be disqualified from holding office for 5 years. So that is the general overview I can give you of this legislation. So again, I think, quite frankly, my personal opinion is that the global model makes sense. I've always been in favor of big professional boards, whether it's for municipal affairs or the labor board or other very important administrative tribunals that, you know, administer justice in this province. But as with any new system, there's always uncertainty. There's always things that are not quite clear. I hope and I trust that in the fullness of time, we will get clarity and answers on these items that I've discussed that are not clear to me at the very least. Hopefully they'll become clearer. So on that, I'll open it up for questions if anyone wants to ask a question or discuss a particular topic with respect to this new commission.
Well, it's good to know our concerns were unrealistic. We were quite concerned as an association with this act. My question is more for Pierre. Pierre, are we able to articulate some of the questions that Sacha asked and submit them under signature to the province? Yes.
Thank you. I have two questions. I guess if I understand correctly, if somebody, for example, I'm a city councillor in Moncton, New Brunswick. My name is Charles. So if somebody, for example, objected to someone who's elected as an official, and if they banded together and over 25 residents came to council and requested the removal of someone, do I understand correctly that that would go to the commission and the commission would investigate based on having 25 people plus one come before council?
Okay, not quite. So this concept of 25 or more citizens, you know, concerting and seizing the commission with a question is not with any question. That's really with respect to restructuring a local government. So be it shrinking a government or expanding a government, but it would not cover questions with respect to one particular elected official as to whether or not they were properly elected or that they've somehow not properly discharged the duties of their office. So there would be other avenues for that to be called into question or investigated by the commission, but it would not be triggered by a group of 25 people or more signing a petition.
So I guess it depends on what's written in the regulation. Because, for example, let's say that a municipality decides they have to raise taxes or they have to do specific things. And a majority, which is 25 plus, decide that, you know what, we don't want that, particularly in light of the reorganization and some of the urban boundary increases, then it really could trigger that, because unless I'm wrong, but I guess it's going to depend on how the language is, because then you could get yourself into, well, okay, now we have to entertain it. And that's, you know, we've always come back on saying, well, but that's why we elect individuals, and then we try to balance that off. So I don't understand what that is and what the safeguard, what it does, other than it gives a minister and a commission more power to sort of oversee.
Yeah, so certainly the legislation, when read as a whole, and when we look at the different sections and the different functions of the commission, it does not create a system whereby the commission would be seized of anything by referendum, if you will. Okay. Like, that's not the case. So citizen-led initiatives that can be reviewed by the commission are fairly limited.
Okay.
Okay?
Right.
So.
Okay. And my second question would be with the code of conduct. Because I think it's really important, and it's great that all municipalities are mandated to have a code of conduct. And I listened to your presentation in terms of how it should be dealt with, and then when the decision is made, the bothersome thing is it comes back to City Council. And we've been through, our council have been through this. And so I always have wondered, and I could see councils triggering this and going to the commission, because we often get criticized in terms of voting on things that we for example, we have to vote on an increase in taxes, or we have to we vote on increasing salaries of councillors because of an independent report. Well, you're voting yourself a salary. And I've found that very problematic with code of conduct. And so I can see that going ahead. And I just want to sort of put that out because it's very uncomfortable when you're, because some people may say, oh, well, was it really, did it really play out that way? If someone felt it was disrespectful, that's the way the person has been, and so on. So I just want to put that out there because I think that's the flaw with the code of conduct. We've had a number of instances, and I think I could see this commission helping out because then it's independent, and then it's scripted, and then it's someone else saying, okay, this actually happened, so this is what we need to do.
So look, I appreciate your comments, and I do recognize the awkwardness of the system as it exists, by which, an elected official can be at times a complainant, at times a witness, and at times an adjudicator, and sometimes wearing two out of those three hats. And so it is an awkward type of system. I'm not sure it doesn't work at all, but it is awkward, and I do appreciate that. Which is why when I saw the new legislation come out, I thought, oh, I know what they're doing. They're going to remove this completely from municipal governments, and they're going to create effectively a code of conduct tribunal, which would, prevent this, we initiate something, but it comes back to us. But that does not seem to be what they've done. Because of that, if it cannot be resolved pursuant to the Local Governance Act, well, then that means, I don't know, we have to go through the system as we know it until we then reach the new way of looking at things or the new way to adjudicate them. But then you're really doubling your costs and you're significantly reducing your efficiency. So to me, that's why the new system has kind of puzzled me, because I thought it's either you do away with codes as we know them, you keep the codes, but you really delegate the adjudicative function to a permanent external tribunal, and that model exists elsewhere, by the way, so the New Brunswick model exists elsewhere, but there are other models in Canada that are more akin to what we're discussing. With this new legislation, it seems that we don't truly know what the system is. So, yeah.
Hi, Sacha. Donna Reardon in St. John. We've met over the phone.
Yes.
I guess I'm just going to give you a little bit of my reaction to all of it. When I hear it all and see it all, there's not very much enabling or strengthening language in that for municipalities. And I guess when, you see the presentation, every slide has the word, of course, power in it, orders in it, directives in it. And that's really not the way to deal with someone who you claim you want to be a partner with to move forward. So that's my reaction to it. And it's not the sentiment. It's interesting that we've heard today from the couple of representatives from the province of New Brunswick who've been here to greet us and speak to us today. That language that's up there isn't really what they claim the road they're on. So it's confusing for municipalities as we go forward. We want to be strengthened and we want to be able to move forward, but it seems like the autonomy will now lie completely, even when it comes to us trying to manage our own small areas. The autonomy lies with someone else, so that's not a good business relationship. Anyways, I do appreciate coming in today, though, to give us an update on it.
And I do appreciate that because, any system has to have checks and balances. So checks and balances are good. But when you put them all on a slideshow like this, you kind of feel that, well, wait a minute, this is not checks and balances. This is more external governance, right? Where, to your point, you lose your autonomy. So, I think that there's a bit of a sense of that. Is it that catastrophic? I don't know. Powers that exist but are exercised judiciously should not be bothersome, but where powers exist, they're discretionary, and discretion is pretty much unfettered, then, it becomes a question of, well, how far will the power holder go to exercise their power. And that can effectively diminish autonomy by municipal governments. So.
I'll go in English, but you're going to have to be patient with me. And I'm going to go the same way that Donna and Stephen is going. At the beginning, when I saw that law, I said, what the heck? What kind of power we're going to have locally? Because the power of the minister, I know probably you don't have control on that, but I have to say it. How are we going to do the job that we're going to do with people, with citizens? And I was wondering, and you talk a bit about in the other province, do we see minister with that kind of power? Do we see commission who have that power? Because what's going to happen, it's our people, when we're going to be struck with something, we're not going to be there to solve the problem. Somebody else is going to solve the problem. Then again, when you go in politics, it's because you want to fix things. You want to go forward. But now in New Brunswick, and if the minister would be here, I'll say it loud and clear, a lot of what we have to deal with, and I agree with the provincial code, or that's not my issue. My issue is the power that the minister have now. Like Donna said, autonomy is not going to be there anymore. Then I don't know in other province, I don't know if you have anything on that, how they deal. It is the same thing that we have right now in New Brunswick.
So I've never undertaken like a coast-to-coast review of municipal regimes to tell you exactly how little or how much power the minister has in any given province. In all Canadian provinces, the minister does retain authority, again, because there needs to be a system of checks and balances. So we need the minister to step in, for example, to, investigate and come to the rescue of a failing municipal government, for example. So there's all kinds of reasons why we would want, some, overarching power to be able to step in and fix problems. The extent to which the minister can easily or not easily do that in New Brunswick versus Nova Scotia versus BC, I really couldn't tell you. I'd love to find it out. I hope maybe one day someone will ask me to look at it, and I'll look at it properly. In fact, I was thinking that would be a really good research paper for a university professor. So maybe I'll talk to my wife. Maybe one of her colleagues would want to do that. My wife's a law professor. So I don't know, but I mean, it's a question of degrees. So, ministerial powers exist in various degrees in all different jurisdictions. But I think the sentiment, if I can express it maybe differently than I already have, is, we need the courts to be there to adjudicate things when needed. But one does not want to live their lives being taken to court over every decision that they make. So again, it's a question of exercising powers or doing things judiciously so that the checks and balances are there when needed, but they don't clog up the system. So I think that you all seem to have a sentiment that there's way more opportunity to basically take you to court or take you before the commission or ask the commission to investigate. And I can see that sentiment because when you consolidate all of these concepts into one piece of legislation and you decide that we're going to create a commission with a full-time commissioner and members and investigations and audits, then it is kind of scary. It does make you pause and think, like, are we really at liberty to exercise our duties? And once in a while there's a problem and maybe we need to remedy that, or are we constantly being challenged or, complained against and ask for someone else to come and overrule our decisions? So I understand how that sentiment is born out of initiatives like this.
Hi, Sacha. Nice to meet you in person again after having talked to you on the phone for many hours. When are the regulations likely to drop And are you willing to come back and do a presentation like this with the full scope of Act and regulations? Because I think it's only then that we'll
Yep.
get to know how terrible this might be for us,
Yeah.
or beneficial, to put on an optimistic hat.
So the white paper basically was calling for the commission to be running and operational at some point in 2024. So I'm thinking the regs are going to come later this year, early 2024, if they then hope to be able to proceed to the nitty-gritty of, we need to appoint members, we need to find a commissioner, so I mean, that's all logistics that take time. So my expectation would be we'll get regs like late this year or early 2024. I will tell you this, with respect to other legislation, which I will not name, but I remember waiting for regs for 7 years before. So we had legislation that was, like it was an actual statute of the province, but was not operational, was not proclaimed into force because we were waiting for the regs, and we waited for, I think it was 5 or 7 years. I hope this is not going to be the case, or maybe some of you hope it's the case, so you can kind of, avoid having to deal with this. But, if we look at what the plan was and what the discussion has been, I would expect regs in the next 6 months about, yeah.
Hello, Ruth Breen, Councillor for the City of Fredericton. Can you offer any kind of clarification on whether you foresee an overarching provincial code of conduct that the Commission will put out? Or will the Commission deal with each unique code of conduct in each municipality, which could be very different from one municipality to the next?
Yeah. So right now, the way the legislation is drafted, local codes will continue, and there will not be a single or additional provincial-wide code. So there's absolutely nothing in this legislation to do that. So the commission will have to, depending on what matter comes before it, look at the code of that particular municipality.
And given that, are they not concerned then that as municipalities try to maintain some democratic control, given overreaching ministerial powers, that they won't just all default to the very minimum standard code of conduct laid out in the Municipalities Act?
I mean, that's possible. I think at this point, because every municipality, or at least most municipalities, have passed a code, it's kind of hard to basically say, let's dilute it and bring it back to the bare minimum. So I think, municipalities are likely to keep their codes as is. And let's be frank, codes don't vastly vary from one place to the next, right? I mean, they look and feel pretty much the same way. But procedurally, they can be a bit different. So, and that was for each municipality to say, what's the best fair process, but best given our reality to process these things and adjudicate them. So, yeah.
Marc Melançon, Ville de Dieppe. Would this apply to arm's length committees to the city? Wastewater Commission, Art and Center committees? Would this apply to these groups?
So the code of conduct that we're discussing, no, because that's the code of conduct for elected officials. But, however, the commission does have power to investigate into the conduct of any office holder. So I believe that could very easily apply to appointed commissioners, for example, on various municipal commissions. Yeah.
Eric McGarity, City of Fredericton. In your analysis, did you compare what the minister has currently as compared these new powers? Have you had a chance to analyze both? Because I know there was an RSC that was very dysfunctional. Minister appointed a trustee to keep that RSC going. So
yeah. So it's a really interesting question, and I've been thinking about that for a little bit. My sense is that at the end of the day, if we go back to core constitutional principles, the minister always had all these powers, because constitutionally speaking, municipal governments don't have to exist. You know, so any power they have is delegated by the province. So from that perspective, the minister always had all of these powers. I think it shines a light on them when they're spelled out that way. And perhaps the way legislation was drafted before, and because we had to resort to reading 4, 5, 6 different pieces of legislation to really understand the overall system, then maybe it was a little less easy for the minister to exercise some powers that he probably no doubt had, but it was maybe a little bit more cumbersome. With this new legislation, it basically glaringly spells out the powers, and it makes for a fairly easy pathway to exercise these powers.
So saying that, has the minister, or has this new Bill 45 extended those powers? And
I think legally speaking, I'm not sure the powers were extended. I think they always existed, but they may have been unencumbered, if you will, by doing away with a lot of restrictions that would be found in this piece of legislation or that piece of legislation, basically doing away with all of that, reconstituting all the powers under a single piece of legislation with pretty much discretion to exercise or very minimal procedural steps to exercise. So I think the powers always existed. I think they're just easier to use at this point. Well, not at this point, when this comes into...
Yeah. My last point is there a possibility for a municipality to get into a legal argument with the province on not a code of conduct, but a bylaw? And the fact being that councillors and mayors are democratically elected, putting that power back into, well, the minister thinks that bylaw is not good. Wait a minute, you're overriding the democratic process. From a legal standpoint, does the city have a case on something like that?
So it could, and I can foresee that there would be a clash. And so let me explain that for a moment. So, you know, powers are, you know, can be very well defined, and they can be, very restricted in how they're used. But most powers by administrative tribunals and bodies are discretionary in nature, right? So we require the decision maker to exercise a power based on exercising their discretion and factoring in things like, is this good? Is this in the best interest of our government? Does this make sense? Is it fair? All of these kinds of things. And so what I fear in a way is that the minister having discretionary powers to question things that are born of decisions that are discretionary in nature by governments who try to do the right thing, there's a clash of discretionary powers, if you will. And so then it becomes, well, how do you adjudicate these things? There are conflicting decisions born out of equal discretionary powers. And so do we then start to call into question, are you exercising your discretion appropriately versus me? Who's being more reasonable, who's being less reasonable? So that's where I see the clash of, how much wiggle room is there for a municipal government to exercise its discretion in various matters without being interfered with by the minister,
Just a comment. So really, with this bill, we are not a level of government, even though they say we are. We aren't.
I understand what you're saying. Let's just say it all depends on how discretionary powers are used, to put it simply.